Imagine this. You're a big company. You get a letter from the federal government. It says, in bold, all caps, that you owe $57 million. Pay within 30 days. And it tells you exactly where to wire the money.
Okay, that sounds pretty binding.
Right? But here's the thing. The government says it's not. They say it's basically just a suggestion. A very serious suggestion with a 30-day deadline and an official federal seal, but still, a suggestion.
A $57 million suggestion.
And here's the wild part. 2 different federal appeals courts looked at the exact same legal question, and they reached completely opposite conclusions. That circuit split, that's the term for when 2 federal courts can't agree, that sent this case straight to the Supreme Court.
Welcome back to the High Court Report. Today we breaking down FCC versus AT&T and the companion case, Verizon versus FCC. It's a constitutional showdown over whether the 7th Amendment, that's your right to a jury trial, means anything when a federal agency decides to hit a company with a 9-figure fine. The Supreme Court hears oral arguments on April 21st.
Quick reminder, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report.
And look, if you enjoy watching constitutional law get tested by a $57 million fine and a Missouri sheriff snooping on a local judge, which, yes, that's where the story starts, then you're already exactly our kind of listener. Questions about this case? Reach out to us on LinkedIn at the High Court Report. All right, here's what you need to know.
So here's the official question the court must decide: whether the Communications Act of 1934 violates the 7th Amendment and Article 3 by letting the FCC order telecom carriers to pay penalties for failing to reasonably safeguard customer data without guaranteeing those carriers a right to a jury trial.
Okay, let's break that down. Let me quote the 7th Amendment because it matters. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. That's it, $20. That threshold dates to 1791. So the drafters set the floor at $20. And we're now talking about $57 million.
Which clears the threshold. But here's the key word: suits at common law. The whole case turns on what counts as a suit, whether an FCC penalty proceeding qualifies, and whether a jury needs to show up before the government locks in its judgment, or whether a theoretical jury opportunity somewhere down the road counts.
And the statute at the center of all this? What does it actually require companies to do?
So the Communications Act has a provision called Section 222. It puts telecom carriers under a legal duty to protect what the law calls Customer Proprietary Network Information, CPNI. That's data about when, where, and how often you use your phone, your location, which numbers you call, information that the carrier obtains solely because you're their customer. And the FCC enforces that with fines under Section 503.
Right. The enforcement works in 2 steps. First, the FCC issues a notice of apparent liability, basically a charging document. Second, after the carrier responds in writing, the FCC can issue a final forfeiture order. That order names the amount, demands payment, and gives the carrier 30 days. Section 504 of the Act says if the carrier refuses to pay, DOJ can sue to collect, and that collection suit shall be a trial de novo, meaning a brand new trial, potentially before a jury.
Got it. So the question is, does that back-end jury option satisfy the Constitution, or does the 7th Amendment require a jury before the FCC locks in its judgment?
That's exactly the question. And the timeline of how this reached the Supreme Court is absolutely wild.
How wild?
A Missouri sheriff used a telecom loophole to track a local judge, and now AT&T and Verizon are fighting the FCC over $57 million. And the future of administrative law? Wild. So walk me through what actually happened.
AT&T and Verizon both ran programs called location-based services, LBS programs. With customers' consent, They let third-party companies access real-time device location data. Think roadside assistance from AAA, fraud alerts from Bank of America, emergency response from Life Alert. The data flowed through two aggregators, companies called LocationSmart and Zumigo, who contracted with the service providers. Carriers required security measures and ran regular audits. That sounds reasonably controlled, until it wasn't. In May 2018, the New York Times reported that a company called Securus Technologies, one of the permitted service providers, let a Missouri sheriff access location data for hundreds of people without proper consent verification, including a local judge. Securus's system required the official to check a box certifying permission. That's it. No actual verification. The sheriff just checked the box.
So the safeguard against abuse was an honor system. An honor system the sheriff abused. Both carriers terminated Securus's access within days of the story breaking. They wound down their entire LBS programs by early 2019. Then the FCC launched an investigation covering all four major wireless carriers. In February 2020, the agency issued notices of apparent liability. The charging documents proposing a $57.3 million penalty against AT&T and roughly $48 million against Verizon.
And then?
And then the carriers submitted written responses. And then the FCC sat on it for 4 years. In April 2024, 4 years later, the FCC issued final forfeiture orders. The agency found AT&T committed 84 separate continuing violations by counting each aggregator and service provider that remained in the program for more than 30 days after the New York Times story. Verizon, 63 violations. The FCC called the resulting fines eminently conservative.
Eminently conservative for $57 million.
The agency pointed out it could have counted every AT&T subscriber as a separate violation, which by its own math would have produced penalties in the hundreds of trillions of dollars.
Hundreds of trillions. That's more money than exists. Both carriers paid rather than defy the orders, because paying triggered the right to appeal immediately to a federal court of appeals. AT&T went to the Fifth Circuit, which vacated the penalty and said the scheme violates the Seventh Amendment. Verizon went to the Second Circuit, which upheld the penalty and said the back-end jury option satisfies the Constitution. Sprint went to the D.C. Circuit, which also sided with the government. That three-way split, Fifth Circuit versus Second and D.C. Circuits, sent these cases to the Supreme Court. Cert granted January 9th, 2026.
So the court took this because the circuits genuinely can't agree on whether companies have a constitutional right to a jury before the federal government locks in a 9-figure fine.
Exactly. And it connects directly to the court's 2024 ruling in SEC versus Jarkissi, the big case where the court struck down the SEC's in-house civil penalty proceedings as a Seventh Amendment violation. This case asks, does Jarkissi's logic apply to the FCC too?
Okay, let's get into the arguments. What do the carriers say?
AT&T and Verizon open with a point the government doesn't even contest anymore, that the Seventh Amendment applies here in the first place. The FCC's claims look like common law negligence. The duty to protect CP&I parallels the classic legal duty to exercise reasonable care. The remedy, a financial penalty calibrated to the gravity of the violation and the carrier's culpability, looks exactly like a common law damages award, and the money goes to the U.S. Treasury, not to injured customers. The carriers quote Jarkissi for the proposition that a remedy designed to punish wrongdoing rather than restore the status quo constitutes the prototypical common law remedy. So the carriers get past the threshold question. The Seventh Amendment triggers.
Now the fight moves to whether the FCC scheme satisfies that right. The carriers say no, because the Seventh Amendment entitles them to a jury before the FCC enters final, binding orders. They point to a 1920 Supreme Court case, in Re. Peterson, which held that no adjudicator, court, or agency may finally determine any of the issues in the action without a jury's help. And the FCC's orders do exactly that. Both orders declare in bolded, capitalized text that each carrier is liable for a monetary forfeiture and demand payment within 30 calendar days. That's not tentative. That's not advisory. That's final.
But the government says carriers can just refuse to pay and get their jury later. And the carriers call that option a fiction. Here's their analogy, and it's a good one. Imagine a final court judgment sitting on the books ordering you to pay. Your only way to demand a jury is to defy the judgment. Make yourself a debtor to the federal government and wait up to 5 years to see whether the government chooses to sue you to collect. Meanwhile, the judgment sits on the official record, damages your reputation, and your main regulator, the one who controls your operating licenses, holds it over every future interaction.
And carriers never actually take that path, not once. In the 47 years since Congress created the current system in 1978, no carrier has ever received a Section 504 jury trial. 0. The carriers argue that unbroken track record is the proof. The supposed jury right doesn't function as a right at all. They call it unavailing for their protection, language they pull from a 1899 Supreme Court decision called Capital Traction Company versus Hoff.
Okay, what does the government say?
The FCC and the Justice Department lead with a statutory argument that reframes everything. They say FCC forfeiture orders don't actually require carriers to pay anything. The legal obligation to pay arises only if DOJ sues and wins in district court. Under the government's reading, shall be liable in the statute means the government may sue, not that the carrier must immediately pay. They point to decades of FCC guidance telling regulated parties they may lawfully do nothing after receiving a forfeiture order. They note that interest doesn't accrue. Forfeitures don't become debts until a court orders payment.
So the government says this is a two-step process, and the jury step comes second.
And they say the Seventh Amendment applies at step 2, the collection suit, where carriers get a full de novo trial. Their anchor case is Meeker versus Lehigh Valley Railroad from 1915. In Meeker, the court upheld a statute that let the Interstate Commerce Commission issue non-binding damages awards against railroads, which shippers could then enforce in civil suits with jury trials. The government says the FCC scheme tracks Meeker closely, with one difference that actually favors the government. The de novo trial in Section 504 gives carriers a complete fresh start, with the FCC's findings carrying no evidentiary weight at all.
Stronger protection for the carrier, not weaker. And the government adds a historical argument. Since before the founding, legislatures authorized justices of the peace to decide civil disputes first, with jury trials available on appeal. That practice carried straight into federal law. Congress replicated it for the ICC in 1889 and has used similar structures for agencies across the government ever since. The government lists 5 other agencies running at least 11 statutes on the same model right now.
And on the unconstitutional conditions argument, the carriers claim that the scheme coerces them into waiving their jury right. The government calls that overblown. They cite Section 504C, a provision barring the FCC from using an unpaid forfeiture order against a carrier in any future proceeding unless the forfeiture gets paid or a court orders payment. The government also notes that AT&T itself argued the opposite position in a 2002 federal court brief, describing the carrier's ability to refuse payment as a lawful statutory choice, not a constitutional trap.
So that's where the legal battle stands. What does this actually mean for real people?
Let's walk through both outcomes. If the carriers win, if the court holds the current FCC scheme violates the Seventh Amendment, the FCC loses its primary enforcement weapon. Forfeitures drive the agency's entire enforcement program privacy rules, robocalling enforcement, pirate radio prosecution, data security requirements. The Communications Act removed common carriers from the FTC's jurisdiction. No other federal agency steps in if the FCC loses the power to impose fines. The government warns that the result could mean significant portions of federal communications law go effectively unenforced.
That's a real-world consequence for every phone and internet user. And the ripple goes further. At least 5 other federal agencies, the Department of Energy, Health and Human Services, the Fish and Wildlife Service, Customs, the Federal Energy Regulatory Commission, all run the same kind of structure. A broad ruling could destabilize their enforcement programs too.
And if the government wins?
Then federal agencies retain the power to impose multi-million-dollar penalties through in-house proceedings that don't include a jury at any point a company can practically access. The FCC could describe a $57 million fine as eminently conservative and note it could go higher, much, much higher, and regulated parties' only realistic option remains paying and appealing to a court of appeals that reviews the agency's record under deferential standards. So either outcome creates significant consequences. The carriers say jury rights get gutted. The government says regulatory enforcement gets gutted.
That tension is exactly what makes this case genuinely hard. Now, what should we watch for at oral arguments?
Justice Gorsuch will press the government hard on jarcossy. The majority opinion he wrote 2 terms ago emphasized that what matters is the substance of the action, not where it's brought. The government needs to explain why the FCC scheme differs materially from the SEC scheme jarcossy struck down, beyond pointing to the Section 504 back-end option.
And I expect Justices Thomas and Alito to push the carriers on Meeker. The government's reliance on that 1915 case is significant. The carriers say Meeker addressed only an evidentiary presumption, not the constitutionality of the underlying agency adjudication. That distinction will get tested. Watch for questions about Section 504C, the provision barring the FCC from using unpaid orders against carriers in future proceedings. The carriers say it's narrower than the government claims. The government says it fully protects carriers who decline to pay. That textual fight could drive the unconstitutional conditions analysis.
And watch the justices who expressed concerns about Atlas roofing in jarcossy. Justice Thomas wrote separately to cast doubt on any scheme where agencies impose civil penalties with only deferential appellate review. He specifically pointed to de novo review as the constitutional fix. The government's whole case rests on de novo review being available. Whether the court treats that as genuinely accessible, given that no carrier has ever used it, might determine the outcome.
Bottom line, time. Why does this case matter?
Because it determines whether the 7th Amendment right to a jury trial means anything in the modern regulatory state. If you run a business regulated by the federal government, and that covers energy companies, broadcasters, financial firms, telecom carriers, manufacturers, this case directly controls whether a federal agency can impose a 9-figure fine on you through an in-house proceeding, with your only practical option being to pay up and appeal to a court that reviews the agency's work on a deferential standard.
And on the flip side, if agencies lose this power, the question becomes whether federal regulatory programs can function at all without the ability to impose and collect monetary penalties. This case marks one of the most significant administrative law confrontations since jarcossy, and the court's answer will shape how every major federal agency enforces federal law.
Thanks for listening to today's episode. If you made it this far, share this episode with someone who thinks the words administrative forfeiture proceedings don't affect their daily life.
Because if your phone carrier decided your location data didn't need much protecting, and then got fined $57 million for it, this case affects you.
Please follow, rate, subscribe, share, and review on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you want to argue about whether a bolded, all caps, 30-day payment demand from a federal agency counts as non-binding, reach out on LinkedIn. We genuinely want to hear from you. Talk to you soon.